Welcome back to U.S.S.G channel. My name is Anton Vieltsin. I'm a criminal defense attorney in the Southern District of California here in San Diego. Today we're going to look at the Federal Sentencing Guidelines Section 2B1.1, which applies to theft, embezzlement, receipt of stolen property, and other fraud statutes. And then we're going to look at the Ninth Circuit case, which helps us define the word victim under these statutes, and whether a particular enhancement for having a number of victims applies on the particular facts. In this video, we're discussing United States versus Kirilyuk, which is a Ninth Circuit case that deals with the Sentencing Guidelines Section 2B1.1, which governs or applies in fraud statutes. So here's what happened. Mr. Kirilyuk was convicted of wire fraud, mail fraud, and aggravated theft. He was later sentenced to 324 months. But here's something for you to understand. If an individual is found guilty at trial, or if a person accepts responsibility and pleads guilty, between the period of pleading guilty and sentencing, there's usually 2 or 3 months. During that period, a probation department comes in and interviews my client or the person who's found guilty. Now, most of the questions deal with the individual's prior history, their medical history, employment history, family characteristics, and so on. The report gives a broad picture to the judge about my client. Now, one of the things that the probation department does is they calculate the federal sentencing guidelines. Every federal case is guideline driven. Before an individual can be sentenced, the federal judge has to calculate the sentencing guidelines. In the guidelines, there's a table. In the top of the table, and I'll put it right here, there is columns 1 through 6. Those are your criminal history categories. And on the left side as rows, you have offense levels. The intersection between those two gives you the advisory guideline range. Now, just like the word means, it's advisory, not mandatory. The judge makes the ultimate decision. They can go higher or lower than what the guidelines say. So it is important for you to hire a good attorney. They can fight for you and try to lower the guidelines. Convince the judge that certain enhancements do not apply and the mitigation factors do apply. Now, before the individual sentence, there are 3 recommendations. One by your defense attorney, the other one by the prosecution, and the third one by probation department. In this case, the probation department, after looking at section 2B1.1, suggests an enhancement because there are 10 or more victims. This particular section says that there's this enhancement of 2 levels, which increases the guideline range, obviously, if there are 10 or more victims. In fact, the PSR, the pre-sentence report, says that there are roughly 120,000 victims whose American Express accounts were used and 222 students whose transcripts were stolen. Now, Mr. Kirilyuk says there are only 2 victims when he goes on appeal. He says there are 2 victims, Chase Bank and American Express. Why? Well, because the victims, the 119,000 people, were all reimbursed for their losses. And the transcripts cannot be measured in money. So he says there are really only 2 victims. So here's where it's important to look at the guidelines. In the comment section, the guidelines define the word victim. Victim is any individual whose means of identification was used unlawfully or without authority. Now, of course, we have to now define means of identification. Means of identification means any name or number that may be used alone, or in conjunction with any other information to identify a specific individual. So of course we now know credit card numbers, student information, social security numbers, they all define, they're all means of identification of an individual. They don't identify Chase Bank or American Express. Those numbers, social security numbers, in fact identify people, individuals, victims. So in this case, the Ninth Circuit says that the PSR was correct, the probation department was correct to suggest that there are 119,000 victims, and that the district court was correct in applying this enhancement. I hope you now understand a little bit more how we define the word victim in the fraud sentencing guidelines. If you have more questions or comments, leave them below. If you like this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. Thanks for watching.